Supreme Court of Canada, Case Study Number 1, Athey v. Leonati. This case was decided in 1996. Athey is a leading case on causation in Canada. Athey was an appeal from the BC Court of Appeal. The facts in Athey were plaintiff with a history of back problems in 2 car accidents in February and April 1991, suffering neck and back injuries. There was no dispute over the defendant's liability. The plaintiff, under medical advice, began physical rehabilitation from the second accident and aggravated back problems. The BC Supreme Court decision, the plaintiff was awarded 75% of damages due to other causes contributing to the injury. At the BC Court of Appeal, the decision was upheld on appeal. There were 2 issues for the justices to consider in Athey. 1, did the Court of Appeal err in failing to hold that the trial judge's apportionment of causation was a reversible error? 2, did the Court of Appeal err in limiting the scope of judicial review by declining to consider the appellant's theory of liability? The respondents' main arguments were: 1, apportionment between tortious and non-tortious causes should be permitted. 2, apportionment is permitted where the injuries caused by 2 defendants are divisible. 3, the trial judge's assessment of probabilities in causation was similar to the assessment of probabilities routinely undertaken by courts in adjusting damages to reflect contingencies. Finally, the defendant argued that the plaintiff was predisposed to disc herniation and that this is therefore a case where the crumbling skull rule applies, making the tortfeasor liable for the plaintiff's injuries, even if the injuries are unexpectedly severe owing to a pre-existing condition. In summary, the appellant's arguments were: 1, the defendant's negligence materially contributed to the defendant's injuries. 2, the defendant's subsequent rehabilitation injuries were a result of the accident, not a cause. 3, as the defendant caused the injuries, the defendant was liable for 100% of the plaintiff's damages. 4, the BC Court of Appeal erred in not considering the plaintiff's arguments on appeal. The court allowed the appeal, holding that the trial judge erred and failed to hold the defendant fully liable for the disc herniation after finding that the defendant had materially contributed to it.
Once it is proven that the defendant's negligence was a cause of the injury, there is no reduction of the award to reflect the existence of non-tortious background causes.
The Supreme Court also found it a mistake to refuse to consider the appellant's arguments on the grounds they were not raised at trial.
The general rule is that an appellant may not raise a point that was not pleaded or argued in the trial court unless all the relevant evidence is in the record. In this case, all relevant evidence was part of the record.
The appeal was allowed with the defendant responsible for 100% of the plaintiff's damages. Athey's legal legacy is that it confirmed the but-for test as the test for causation and negligence, as well as the principle of material contribution in Canada. To succeed in proving causation, the plaintiff must prove that, but for an act of negligence, he or she would not have suffered the resulting harm. The negligent act need not be the sole cause of the injury. It just has to materially contribute to the single indivisible injury.